If you have been injured because of someone else's negligence, perhaps you thought about pursuing a claim, but did you know that your health insurer might ask you to reimburse them out of that settlement? In this week's Know the Law segment, Tom Sinas joining us to better explain. And Tom, let's talk about the basic concept of a health insurer lien and why it's so important for us to understand.
It is such an important concept, and yet people don't usually think about it or encounter it until they have a claim. And this stems from the very nature of what it is that people pursue in a personal injury claim. One of those things that people can pursue in most personal injury claims are claims for medical expenses. That means those medical expenses that they've incurred in the past as well as in the future. Well, most people have their medical expense bills paid by some form of health insurance, whether it's private health insurance through your employer or a government administered health insurance program like Medicare or the Medicaid program. When those health insurers pay medical expenses on account of someone's injury, if the victim receives a recovery from whoever is at fault for the incident, then those health insurers have what we call a lien, or a claim for subrogation, which simply means a right to be paid back out of a portion of the victim's settlement from whoever is at fault for the incident.
Well, let's talk about this, the new no-fault law. Obviously, Tom, how will the health insurer liens be affected by those new laws?
Well, this is really unique, Derek, because up until now, the issue of health insurer liens really didn't affect auto accident victims. And the reason was because under our old no-fault system, auto accident victims turned to their own no-fault insurance company for their medical expenses. And those medical expense benefits were the responsibility of their no-fault insurer for life. What that meant is that at-fault drivers were not liable for another person's medical expenses. And what it also meant is that a no-fault insurance company, if it paid medical bills on account of a victim, could not assert a lien against the victim's tort recovery, against the recovery against the at-fault driver. These rules are going to be changed because of changes in the law. People, however, can protect themselves from this problem because under the new law, people can choose to elect the same kind of coverage that we had before, which is unlimited no-fault coverage, and in particular, unlimited, uncoordinated no-fault coverage. If consumers elect that coverage, then if they are involved in an automobile accident, they should not encounter the problem of a health insurer lien, which protects them because it means that any recovery from a liability settlement will go to them and them alone.
Yeah, okay. Interesting stuff, Tom. A lot of changes coming our way. Where do people track you down for more information?
Well, they can find us online at www.sinasdramus.com. As I've said before, we have a new free publication there to help people make choices regarding the new no-fault law. They can send us an email at info@sinasdramus.com or give us a call in West Michigan at 616-301-3333.
All right, good stuff. Thanks, Tom.
Thanks, Derek.